Your Honor, before the court is Crystal Pages. Your Honor, we were here today for sentencing. Actually, kind of whatever we could do to get this all figured out. I've been in discussions with the state. He has made an offer to resolve the issue for my client in regards to sentencing, subject to the court's approval. It would be a 5-year sentence. I have discussed it with my client, and she is interested in getting this over with today. So she would ask the court for that sentence. As I said, subject to court approval.
By way of history, my recollection of the broad contours of where we are is that at some point Ms. Pages had entered some type of assistance agreement with the state, and she was held in custody throughout and for a significant duration of time. And then at some point, the other case, I think it's Mr. Vasquez, perhaps?
Mr. Vasquez, yes.
Okay, he's still pending trial. She was going to testify in his case, but that case has not come to trial for various reasons, including the pandemic and changes of counsel.
That was the cooperation agreement. My client was to receive a 3-year sentence for cooperation in that case. We're closing in on 4 years, as I say, for numerous reasons, which she's discussed with me. She would just like to accept the state's offer of 5 years today.
So at some point, Ms. Page's patience wore a little bit thin, and she entered a plea to the bench, plea colloquy previously, is that correct?
That's correct.
And did the state, Mr. Frazier, have a charge reduction in this case?
Yes, Your Honor. Ms. Pages did plea and was adjudicated guilty to the lesser included offense of robbery, where the original charge was robbery with a firearm as a principal.
I recall that the primary individuals involved in the alleged armed robbery, at least as it relates still to Mr. Vasquez, he's not been tried yet, but I believe the other co-defendant did enter a plea agreement and was sentenced to the Department of Corrections.
Yes, Your Honor. Co-defendant Melvin Presley entered a negotiated plea and was sentenced to 8 years in the Department of Corrections.
And he and Mr. Vasquez are alleged to have been the direct people at gunpoint did the armed robbery.
Yes, Your Honor, that's correct. And they were both charged with 2 separate incidents. Ms. Pages is charged in the first of those 2 related.
Oh, okay, I didn't realize there were 2 incidents.
Yes, Your Honor. There were 2 separate robberies that each of the co-defendants were charged with. Ms. Pages is charged as a principal in the first of those 2 offenses.
And I believe the probable cause affidavit indicated that, according to the state, Ms. Page's role was that of taking the 2 co-defendants to the robbery scene and then serving as the getaway person and then using some of the profits for her own purposes.
That's correct, Your Honor.
So, Mr. Frazier, what's the state's position today?
So, Your Honor, the state's position is that there was a previous offer in Ms. Page's case for a non-cooperation resolution. Because Ms. Pages did enter a plea, even though she does not wish to go forward with cooperation, the state would still be willing to resolve the case to an agreed upon sentence of 60 months in the Department of Corrections.
That's consistent with the prior or different than the prior?
That's consistent with.
Of the non-cooperation plea offer?
Correct, Your Honor.
Credit all time served, I assume?
Yes, Your Honor, and I do have a calculation of credit. Ms. Pages was arrested for this offense on June 30th of 2017. She has not posted bond. The calculation is 1,379 days, and that includes today's date.
Okay, thank you for doing that. So the plea officer adjudication, 60 months, Department of Corrections, credit 1,379 days. Monetary amounts involved?
Yes, Your Honor, there would be court costs. The cost of prosecution in Ms. Page's case would be set at, I just want to make sure that it's not enhanced.
And Madam Clerk, do you have the court costs?
450.
So the standard, okay.
No, there's no enhanced cost of prosecution, so it would be the $100 cost of prosecution.
Investigative costs?
Do not have a note on that, but I do have the case file, which would have that.
Is there any restitution involved, Mr. Fraser?
Yes, Your Honor. The restitution is, if I can have just one moment.
While he's looking at that, Mr. Smith, were you court appointed?
I was, Your Honor.
I assume, Madam Clerk, that there were prior public defender or regional counsel fees, or was that a conflict from the get-go?
Just have the application fee.
That's $50?
Yes.
I had an investigative fee of $370 in the original agreement. I don't know if there was anything in addition to that.
No, that would be the correct amount.
As to restitution?
As the restitution, the exact fee, well,
Are you saying $370 investigation costs in the sheriff's office? Is that what you're saying?
correct.
Okay.
Yes.
And Your Honor, I do not have the exact dollar figure, but the state would resolve with the agreement that it would be a joint severable restitution amount of $9,000. That would be joint several with co-defendant Jeremiah Vasquez, case number 17CF 1325A is an alpha, and co-defendant Melvin Presley, case number 17CF 1325B is in Bravo.
Mr. Smith, does the defense wish to have a hearing or object to any of the monetary amounts, including the substantial joint and several restitution?
Your Honor, my client has informed me she's not is not positive how much was stolen, at least from the probable cause affidavit. I believe that she may have been involved with, I think it was 5,500. So if the state is saying that 9,000 was taken total, I don't really have any way to dispute that.
My friend said we should call that.
She was telling me that she only received $500.
Well, that was the alleged payoff for her service from Mr. Vasquez, but the probable cause affidavit also references that she stashed $9,000 and apparently used it in a $5,000 vehicle.
What my co-defendant told you to get a lot. They're going to tell you the honest.
Well, in any event, though, she is entitled to a hearing. The state would have to prove this.
We can set it here, Your Honor. That's fine. That's fine.
Okay. Mr. Frazier, did you wish to have that hearing this afternoon, or do you wish to set it for another date? Is it only the restitution at issue, Mr.
That appears to be all that's at issue, Your Honor.
I was not prepared to argue the
Well, perhaps this. I mean, perhaps if the state can show Mr. Smith what proof it may have regarding the monetary amount, then Ms. Pages can decide whether she wishes to have the hearing or not.
Fair enough, Your Honor.
But I'll order it subject to, well, I'll order in reserve on that because it has to be proven by the state. And you're unable to address that today, Mr. Frazier?
If I can just have one moment, Your Honor.
All right.
Your Honor, the state would ask that that be set on another date because the state does have some evidence that we would like to get from the sheriff's office.
That's fine. And perhaps if you, in advance of that, do you want me to set the hearing date now? Or do you need to check with your availability of witnesses and things and proof?
Yes, Your Honor. I would like to check the availability, and also that would give me an opportunity to address the specific items of evidence with Mr. Smith, and that may negate the need for a hearing, but we can, I can speak with him and we can request a hearing date.
Okay. Mr. Frazier, I notice, I think we have a detective, I assume, here in the audience. Good afternoon, sir. Welcome. Do you know if there's any objections from law enforcement or any alleged victim to the proposed plea agreement?
Your Honor, my notes indicate that at the time that this was, the original plea offer was developed, that was in agreement with the victims. I would ask, is there any objection to, no objection from law enforcement or the victims, Your Honor.
All right. Was there any request for victim impact evidence to be presented? I assume not.
No, Your Honor, the victim from this particular offense did not wish to be heard.
And restitution would be to the corporation, is that correct, if ordered?
Yes, Judge. The restitution in this case would be to 7 Food Mart.
Mr. Smith, obviously this is a change because understandably Ms. Pages grew a little frustrated at the passage of time. I believe at one point her time in custody exceeded the amount that was agreed to as part of the cooperation agreement. But due to factors beyond everyone's control, including the pandemic, Mr. Vasquez still is pending. Have you had a conversation in private with Ms. Pages prior to this afternoon about this new plea offer or the revitalized plea offer from before?
Actually, Your Honor, today was the first time that we've been able to speak in person. The jail here, to my knowledge, still will not allow face-to-face visits. I believe we can probably still do video. She and I have communicated mainly just through correspondence letters. So,
have you gone over the score sheet and all of the evidence in this case with her?
We have done that long time ago, Your Honor. Like I said, the new offer, and I was kind of up in the air this morning. I wasn't exactly sure what was going to take place. As the court may remember, I was going to file a writ of habeas corpus, which I'm still working on, which was a little bit more than I thought it was going to be. But anyway, the court's decision today may make that a new issue.
Well, I guess what I'm asking is, does Ms. Pages wish to have a few moments in private in attorney conference for her to discuss her options before she makes a final decision this afternoon?
In regards to the plea, I believe she's pretty set on that she would like to enter it and accept that 5-year offer. In regards to the $9,000 in restitution,
well, that'll have to be set for hearing.
yeah, I was going to say we'll have to set that for hearing, but I believe she's pretty well set that she would like to resolve this by means of plea today, or sentencing today.
So, Ms. Pages, you don't need any additional time in private to discuss your options at this point with?
No, that's what I was hoping to get at least 5 years for my thing.
Okay. At this time, then, it appears that she does not need any additional time to discuss this. The court's made the inquiries, everything has been clarified. We had previously done a plea colloquy. Mr. Frazier, do you wish to do a whole or partial new plea colloquy?
Just a partial one, Your Honor.
Okay. And Ms. Page, if you just remain seated, raise your right hand and be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth? Yes.
Thank you. May I lower your hand?
Ms. Page, you understand why we're here today? Okay, and in this case, you previously entered a plea, and do you understand that the court has previously adjudicated you guilty of the offense of robbery?
Yeah.
Yeah. So previously, you did have an agreement with the state where, in exchange for your cooperation in the prosecution of a co-defendant, you would receive a sentence of 3 years in the Florida State Prison. Okay. And today, we're here for an open sentencing where are you in agreement that with the state's recommendation for a 5-year or 60 months in the state prison?
Yeah.
Do you understand that your co-defendant, Mr. Jeremiah Vasquez, is set for trial at the end of May?
Yeah.
And do you understand that if you were to testify truthfully at that trial, that would fulfill your portion of the agreement with the state for cooperation in the prosecution of the co-defendant?
So, Mr. Frazier, is it still the state's position, even as late as today, that if Ms. Vasquez chose otherwise and preferred to do the cooperation agreement and testify in that other case, which supposedly would be tried in May? Of course, there's uncertainty as to whether it will actually be reached based on other cases, based on the pandemic, but there's also a substantial probability it might be reached.
Correct.
At that point, she would be receiving a 3-year sentence at that point if she testified truthfully in that action?
Yes, Your Honor. The state's original offer of 3 years in the Florida State Prison was contingent upon the cooperation against the co-defendant.
But that is still extended to her as of today.
Up until the point that Ms. Page is sentenced, the state would prefer to move forward with Ms. Page's as a cooperator.
So, Ms. Pages, I just stopped there because that is remarkable. I mean, we're potentially about less than 2 months away from what potentially could be Mr. Vasquez's trial date. And the state is indicating, as you've just heard, that if that case were to go forward, if you chose to cooperate in accordance with what you had previously agreed and testified in that case truthfully, this could be a 3-year as opposed to a 5-year sentence if this happens in 2 months from now. Are you sure you want to agree to the 5 years at this point?
Yes, I already have 4 years in.
Okay.
A couple shots a month shy off that. So I only have a year left. And my father just had a stroke and he's paralyzed now. So I would rather take that year than waiting on Jeremiah like I did for 4 years.
So you don't need to talk in private, Mr. Smith, anymore about this decision to be made?
I spoke to him already and
Okay.
explained my concern. I waited long enough for him and he knows what he's doing. He's taking his time.
Okay.
I'm done waiting. Thank you.
Mr. Frazier, you may continue.
So, Ms. Page, with all of that in mind, do you feel like you've had enough time to consider your options of moving forward with cooperation or resolving your case and being sentenced by this court today?
Yes, I had enough time.
Do you need any additional time to discuss this decision with your attorney?
No.
Okay. Your Honor, state has no further questions.
Mr. Smith, any other defense clarifications?
Nothing further, Your Honor.
Now, she understands also that then this would halt any habeas corpus relief that you might have filed on her behalf. Is that correct?
I explained to her that this would make it a moot point.
Ms. Pages, do you have any questions about everything that we have discussed here today?
No, thank you.
So it's your final decision to accept the 60 months with credit all time served plea offer to have this matter resolved, even though if you were patient for maybe a couple more months, or we're not sure, but even potentially as short as another couple months, it could result in basically a time served if she testified truthfully. Is that correct, Mr. Smith?
That's correct, John.
So you understanding that choice fully, you prefer the certainty of this plea agreement at this time?
Yes, thank you.
All right. Mr. Fraser, anything else to clarify from the state?
Nothing for the court, Your Honor. If I can just have a moment to show something, Mr. Smith.
Okay.
Will this conviction result in any particular special designation of Ms. Page's?
Your Honor, it's possible that because it's a robbery, that could have the impact of having her designated as a violent felony offender of special concern in the future if she was to commit a future crime and be placed on probation. That would have a significant effect on her ability to have a bond in a probation case. Because it's the reduced charge from robbery with a weapon, I would have to specifically check the statute to see if the second-degree robbery qualifies under that statute through the designation.
And was there, on the score sheet, was there a designated minimum under the current charge?
Your Honor, I believe there was. I believe the score sheet, if memory serves correctly, came out to about 50 months.
The lowest permissible sentence for the score sheet is 50.8 months in the Florida State Prison. The total sentence point value is 95.8.
With the maximum being on the current charge, what?
30 years.
Mr. Smith, any other clarifications?
Nothing further, Your Honor.
Based on the plea agreement, the plea colloquy, the arrest affidavit facts in support thereof, and the plea of no contest to the reduced current charge, the court finds the plea is entered freely, voluntarily, intelligently, with advice of counsel, that Ms. Pages understands her choices in this matter, including the risks and or benefits of being patient a little longer for potentially still doing the cooperation agreement and a lesser sentence, but at this point it's very clear that she's thought about her options, doesn't need to talk to her lawyer any further. There are no competency issues, Mr. Smith, at any point?
Not that I've seen, Your Honor. No.
And Ms. Pages has responded coherently and rationally. So I think at this point she has just simply decided she prefers, as she told me, the certainty of this plea agreement. And at this time, the court will approve the plea agreement as recommended by both the state and defense. 60 months, Department of Corrections, credit for all time served, at a minimum 1,379 days. Court costs are $415, prosecution $100, investigative $370. The restitution is ordered and reserved. The state to set a hearing on that if needed after showing defense counsel proof that may be presented at hearing or reaching any stipulations in the alternative. Public defender charges are $50. All monetary amounts, I assume, to go to collections, Mr. Smith?
No, that'll be what we're asking.
All right. Now, Madam Clerk, with us having a potential hearing date on the restitution, will that result in Ms. Pages remaining in local custody until that is resolved, do you know?
I don't think so, not unless you guys prepare for her to remain, but other than that, I think she'll be.
So she would just be returned for the hearing date then?
Yes, Your Honor, and I think that's if she's transported before we have the ability. So if counsel wants to agree that as part of today's hearing, we also enter an order that Ms. Pages is to remain in the Collier County Jail for at least 30 days to facilitate us setting a hearing and getting.
What is better for the parties?
My client is comfortable with that, Your Honor.
And Mr. Fraser, you think that's better for the state also?
Yes, Your Honor. I think that if we can, I think that we would likely be able to have the evidence and witnesses ready.
Well, let me
within the
do
next 2
this,
weeks.
since it is affecting her status. What I'd like to do is to get from my assistant a hearing date within the 30 days. If you have to change it, that's fine.
Okay.
But at least we'd have a target, and then we know if, at that point, she either remain or go.
Very good,
All right,
Ron.
let me just set that up now. Now, there's no doubt, Mr. Smith, she'll continue to accumulate credit in the meantime.
Yes, thank you.
Hello, Melissa. On the Pages case, we just need a hearing date, hopefully within 30 days. Now, I'm going to ask the parties in a moment how much time is involved, but it's for a restitution hearing. So let me have you start looking there, and I'll ask them how much time is needed.
Okay, I need to know that.
Okay, just one moment, and then I'll ask them that.
Okay.
Mr. Frazier, how much total time do you think might be needed?
Probably no more than, it could likely be accomplished within 30 minutes, Your Honor.
Would
I
that-
think that
Is that just for the state's presentation?
probably 20 minutes for the state, Your Honor. It would just be some evidence as to the amount of money taken during the offense, and then some statements made by Ms. Pages under oath.
Okay. Mr. Smith, if I set this for 45 minutes, you think that would be enough?
I think that would be plenty.
All right, so Melissa, approximately 45 minutes in the next 30 days.
April 26th at 3:30.
So Mr. Frazier, April 26th at 3:30, is that a conflict for you?
Was that 3:30, Ron?
3:30 on April 26th.
No, Your Honor, I think that I'm already in front of this court on a motion to withdraw plea for Mr. Fahone.
Okay. So obviously, if you run into problems with witnesses or evidence, we can move it. But that would just, then I could have the clerk put on the judgment and sentence that she's to remain until the restitution hearing.
Okay,
So Melissa, we'll go ahead and confirm that for 45 minutes on that date.
Okay.
And I think that's all we needed from Melissa.
Melissa,
Okay, go ahead.
Melissa,
Yes.
you don't have to send a, email to CT supervisors, because I'm gonna set it from here, okay?
Okay.
All right, thank you.
All right, so hopefully that'll bring some finality to all of this if everybody can work together. If not, we'll move the date.
Thank you,
So,
Ron.
judgment, is there anything else that needs to be addressed as part of the judgment and sentence for either side?
Not at this time.
Not for the state.
All right, thank you for resolving the matter, and have a good day, everyone. This matter is concluded until that date. Have a good day, Detective.
Thanks, sir. Yeah, that's one Smith.
Officer Blum, I think we're adjourned, so if you want to disconnect
Well, wait a
first
minute,
one.
Stephen. I just need you to read this.